Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hello, everyone.
Now, in a week of by-elections, downloaded WhatsApp messages, and the London Mayor speaking out to defend ULEZ, what can you tell us, Dennis?
Well, for me, it's back to the COVID inquiry, which has reached a critical point in the first module that's taking place. Michael Gove has given evidence to the COVID inquiry. In the bulletin, there's his witness statement, a transcript, and a video link to the hearing. But what you'll never forget if you look at this is that he said Brexit helped government prepare for the pandemic. Now, I wonder, after listening to this piece, whether you agree with me that this so-called evidence really is nothing more than unsupported opinion. Well, here we go. To be precise, Michael Gove told the inquiry last week that preparing for Brexit meant that the government was match fit to respond to the COVID-19 pandemic. He told the COVID inquiry that civil servants honed and refined crisis skills as they worked up ways the UK could leave the EU. But at a previous session, senior civil servant Catherine Hammond said Brexit had distracted officials. Gove argued that Brexit was the best preparation for any future crisis. Giving evidence last Thursday, Gove said that pace and the intensity of the work of preparing for Brexit ensured a greater degree of match fitness for what was to come. Mr. Gove, who was a senior cabinet minister during the pandemic, said the civil service grew and expanded in readiness for EU exit. And this meant more staff were available to react when COVID spread across the UK, he added. In evidence, Gove explained that he would argue that the skills acquired, honed and refined during EU exit preparation helped them not only to have an organisational system better in dealing with process, but to have a cadre of people who'd been through an intense process that enhanced the ability to respond, he told the inquiry. The inquiry had previously heard that the UK paused the pandemic preparedness plans made in the wake of the 2016 flu epidemic to concentrate upon Operation Yellowhammer, the government's contingency plan for the disruption anticipated in the event of a no-deal Brexit. But former Scotland First Minister Nicola Sturgeon told an earlier session of the inquiry that preparation for Brexit had hampered pandemic preparedness in Scotland. She said that devising contingency plans for a no-deal Brexit meant that a significant amount of time, energy and resource was diverted into that from a range of other matters. And similarly, Wales' most senior medical advisor told the inquiry that preparations for a no-deal Brexit held up work to plan for a future pandemic there. Under questioning from Kate Blackwell KC, Mr. Gove said that he did not agree that the overloading of staff with work on leaving the EU meant their focus was bent away from preparing for a pandemic. Mr. Gove, himself a leading campaigner for Vote Leave, said preparation for EU exit in and of itself was some of the best preparation that could have been undergone for any future crisis.
Now, remote meeting provision for local authorities, our long-standing campaign following our judicial review with ADSO. We were a little excited, although only a little, by the news that the House of Lords narrowly passed an amendment in reliance on the previous Regulation 5 of the regs made under Section 78 of the Coronavirus Act 2020, tabled by Baroness McIntosh of Pickering and supported by excellent arguments that we've been voicing for what seems like endless months. The motion passed by 167 votes in favour to 154 votes against. And it also raised a recent LGA survey, which showed that 95% of authorities wanted remote provision. Of concern to LLG was the fact that during the debate, Earl Howell, who's the deputy leader of the House, said, "I do not mean to cause offence to anybody, but someone whose life is directly affected by a planning decision, let us imagine, would not wish to find that the councillors concerned had taken the decision from their respective living rooms with test match coverage playing in the background." This raised three main points in my mind, amongst many others. First, the overwhelming majority of remote meetings within local authorities took place with extreme professionalism, supported by excellent legal and democratic officers, and attended by councillors who understood the importance of their democratic role and who, altogether, were able to hold open, accountable, and equitable meetings, which actually increased the numbers of general public who took an interest in democracy at the time. Second, what does the Deputy Leader consider that members in Wales actually do while they're holding their remote meetings? Are we to swap cricket for rugby in this analogy? Third, the government, via the Department of Education, has already seen fit to put into perpetuity remote meeting provision for educational appeal panels. Does the parental school choice of a child not potentially have the impact to change the course of that child's life? And yet there was no qualms in enabling that provision once the COVID provision fell away. I'm really struggling, Dennis, to understand why opposition continues so strongly. We're waking up to AI developments every single day, so significant, in fact, that the European Parliament is debating its current AI Act, and the government currently have a white paper on AI. Technology is moving at pace, and yet democracy within England at least stagnates in 1972. Just a reminder that the Information Commissioner's Office have accepted our complaint along with ADSO to review the government's refusal to release submissions collated under their call for evidence. We will, of course, keep you updated on that when we have more news. Dennis.
Well, next, a familiar pattern has emerged over recent months with several large public organisations being reprimanded by the Information Commissioner's Office for significant failures and data breaches in the handling of personal information. But what conclusions can be drawn from all of this? Here's more. The Information Commissioner has been looking back at the reprimands issued in the past 3 months, and here are 3 brief lessons for organisations across the public sector to improve their data protection practices. Number 1, avoid inappropriate disclosure of personal information by having policies in place and training your staff. Now, 5 organisations were reprimanded for disclosing people's information inappropriately in the past 3 months. And what the ICO found was that most organisations did not have appropriate processes and policies in place or adequate staff training. To avoid similar incidents, organisations should review all data protection policies, procedures and guidance, including how to detect and report a personal data breach. And in particular, they should provide adequate training for staff responsible for redactions and disclosures. Number 2, respond to information access requests on time. Now, this is not an option. The ICO reprimanded local authorities for failing to respond to subject access requests within the statutory timeframe. People have the right to ask organisations for a copy of their personal information, and this includes where they got their information from, what they're using it for, and who they're sharing it with. Organisations must respond to a request within 1 month of receipt of the request. However, this could be extended by up to 2 months if the request is complex. And number 3, implement a data protection by design and default approach. Now, the police were reprimanded for rolling out an app that recorded phone conversations and unlawfully captured personal information. These cases are a lesson learned to any organisation planning to introduce an app, product or service that uses personal information. Development and deployment of any new apps should take a data protection by design and default approach from the very start. And this is explained in more detail in the bulletin. Helen.
Now, Dennis, when should public bodies exist? This is a question the Institute for Government has considered in a report in which Matthew Gill and Grant Dalton argue it's time to rewrite the government's outdated tests for creating and closing public bodies, in that they don't meet the country's needs, have led to flawed decisions, and need to be rewritten. Taken directly from the report, it says that the existing tests first set out in 2010, when they were criticised by the Public Administration Select Committee for not being properly thought through and not updated since, may have contributed to misguided or mishandled public body abolitions, with the closure of the Audit Commission, the UK border agency, and Public Health England, informed by a prejudice against quangos. It also warns that Cabinet Office guidance stating that new arm's length bodies should only be set up as a last resort is at best distracting to decision makers and at worst counterproductive, which has, the Institute argues, contributed to government pursuing less effective means of delivering a service or abolishing useful bodies, and has undermined the morale and reputation of those working in public bodies. The report proposes replacing the current narrow tests that focus on impartiality, independence, and technical expertise with 3 new tests that would allow ministers to use public bodies more flexibly and would more accurately reflect the reality of why public bodies are being set up today. A very interesting report. Dennis, what's your last item today?
Helen, I covered a case in the podcast the other week concerning a government consultation that was found to be unlawful. The Court of Appeal has since overturned the ruling that the government's national disability strategy should be quashed, as it was developed without meeting legal obligations on consultation. Let's look again at this to find out why. Lady Justice Elizabeth Lang said Mr. Justice Griffiths had allowed an application for judicial review of the Work and Pension Minister's strategy, having held that a UK disability survey which preceded it was, at common law, a consultation, which attracted various obligations which the Secretary of State had breached. The Secretary of State appealed against Mr. Justice Griffiths' order on the ground it had not been right to hold that the decision to use a survey of public views attracted any legal obligations that the Secretary of State had breached. Lang said, "I have decided that the judge was wrong to decide that the survey was subject to the requirements first described in the case of ex parte gunning. He was therefore also wrong to hold that the Secretary of State had acted unlawfully by not complying with those requirements, and wrong to quash the strategy." She said that the common law does not impose a general obligation to consult, and obligations to do so arise only if there is a statutory duty to do so, if there is a legitimate expectation, or if it would be conspicuously unfair not to consult. Lady Justice Lang said, "In my judgment, the strategy had not reached a stage at which it could conceivably have been the subject of a consultation complying with the gunning criteria. It is not suggested that, at the time of the survey, the disability unit in the ministry had a secret draft of the strategy locked in a drawer. The purpose of the survey was to find out information and views which might inform the strategy." And she concluded, "I do not accept the submission that it was open to the judge to find on these facts that the survey was a consultation to which the gunning criteria could or did apply." But she did reject a second ground on the application of gunning to voluntary consultations. And on this point, Lord Justice Bean said, "It is far from obvious to me that a voluntary consultation should be subject to the same rules as one which the public authority is legally obliged to conduct." But that interesting question, on which there is no binding authority, he said, will have to wait for another case.
Now, the Cabinet Office has launched the second part of its technical consultation on the secondary legislation required to implement the new public procurement regime established by the Procurement Bill. This second part focuses on the transparency provisions and notices that will be used by contracting authorities to fulfil their legal requirements under the bill, and provides the actual script of statutory regulation proposed, which is not often seen in government consultations. This is a detailed consultation and one for experienced practitioners. The notice includes pipeline, dynamic market, qualifying utilities dynamic, termination, tender and payments compliance notice, amongst a total of 15. In addition, the consultation covers organisations included by the term Defence Authority used in the bill and a number of other matters that feature in the draft statutory instrument which relate to transparency. These other matters are the Central Digital Platform, supplier information, which will enable suppliers to submit core information once only, identifiers, which are the unique identifiers for organisations, procedures and notices that the digital platform requires to operate effectively, and the assessment summary. The government appear to be wanting to exempt private utilities from the requirement to publish a preliminary market engagement notice, and also want to hear views on the proposed approach to transitional arrangements for procurements already underway at the time that the new regime enters into force. It's not called a technical consultation for nothing, and perhaps not one for light reading around the pool this summer. The closing date is the 25th of August. And on that note, you can read more on the items discussed today and many more besides by going to bulletin number 28, available on the LLG website now. So it's goodbye from me.
And from me too.
Have a good week.